appeal in the matter of FXJ and the Home Office in another.
Yes,
my lord, my ladies, good morning. I appear for the appellant FXJ with my learned friend Ms Nicolau and my learned friend Mr. Cohen appears for the respondent, Secretary of State and Home Office. Just to say that the appellant himself is sitting at the back of court. I've just spoken to him. He may leave quite soon. He tends not to stay for a very long time in court. Thank you. My lord, my ladies, can I start by talking about the bundles and
yes, I think
apologising?
I'm going to get my apologies in first. You were implicitly ticked off for not supplying them until Monday. As you pointed out, because I was unaware, the letter had told you that the deadline was Monday. That is a computer glitch because the normal rule is 7 days.
Yes.
But the computer doesn't understand about the vacation. I thought that nothing ever happens in the vacation.
Yes.
So please don't feel rebuked in any way. However, just so that I can turn the tables very slightly, could whoever put this together or gave guidance to whoever put it together appreciate for the future that it is not the most helpful to have them in alphabetical order. If you're reading through, especially an area like this where the case law has developed, you want them in chronological order. And these things these days, I gather, are normally done by clerks in chambers, not always, sometimes done by the solicitors, but somebody needs to give guidance. Maybe the Court of Appeal will produce something, but in the meantime, if you're doing another appeal here, could you ensure that the authorities are in a... Otherwise, you're skipping. You can imagine you're skipping a.
My lord, absolutely, yes.
It's a very minor point.
Well, it's me and not anyone else who's responsible for that. I'm afraid it's because
sure
we just
you bear that rebuke. Which is a very mild rebuke.
I've just had an index sent back from in the Rwanda litigation because it was done chronologically and it was decided that it should be.
Really, they have a different rule there.
Yes, they have a rule. Which
Oh
they
wow!
depart from.
Oh, I didn't know that.
So there we
Well,
are.
I didn't know that. Well, it just shows how difficult we make it for you. But still,
Thank you for that. What on the other hand is definitely wrong with the bundles, as you received them yesterday, is that the electronic pagination does not match the
that's a familiar problem. Since I only use them in paper, I didn't notice that. But
So-
my ladies may be more modern in this matter.
I this time have not used a digital bundle.
So if you are using a digital bundle, my ladies, there is a new one submitted this morning where the paper numbers have remained the same, so as not to cause problems, but the electronic ones are
that's
amended.
helpful.
Sounds as though.
Was it sent by email or was
It would have been
uploaded?
filed electronically by my solicitor this morning.
Thank you.
And lastly, on authorities, at a time when I hadn't fully understood the issues, I thought you might find something interesting in the discussion of assumption of responsibility in Benyatov. I will be surprised if you did. So I won't be offended if you don't feel obliged, or if you don't think it's necessary.
We had a discussion. I was going to refer through
But
it.
I mean, all I'm saying is, yesterday afternoon I thought but they better just look at what I said.
Yes.
Now I understand it better. I don't think you'll be helped. But
my lord, I'm grateful. I think that I was going to use to refer through it to
up to you.
something, but yes.
So that's bundles. Anything else by way of preliminary?
No, we have hard copies of the documents that were requested yesterday.
Yes.
So we've got the psychiatric reports. In fact, both of the Katona reports are in here, which I think was not what was asked for. But
if you look at the joint statement, there were several Katona reports.
yes.
What I thought we ought to see is what was before the court, and I assumed that what was before the court was what was in fact, in particular, what was pleaded.
Yes.
So it's the pleaded one that we're most interested in. You might want to put in something else as well.
So, my lord, there is the report which was pleaded to. There was a second report because so much time had elapsed. In any event, there was a second report which was put before the county court. There was also the report of on behalf of the defendant, which you don't have.
Yeah, we got the really, or I don't want to be in a different position from the court below. So I assume what the court below had was the joint statement, and presumably nothing else.
That's right. The high court.
And because this is formally before it, whether they looked at it or not, the one that was served with the particulars of claim. That's what I meant to ask for.
Yes, so you have the one you have two, but the first is the one that was served with the particulars of the claim. Sorry, you need 3. I can give you more. Sorry. Yeah. And also at the back of that bundle is the schedule of loss.
Yes, that's probably less likely to be relevant, but I thought as it was referred to in the pleading, it would be useful to see.
Thank you. And then finally, you'll have received that supplementary bundle yesterday. I don't anticipate that either of us is going to refer to it because there's no dispute about the facts and they're summarised in both of the judgments below.
Well, let's see, but I certainly found it helpful myself.
Well, I thought that the court might. We thought the court might find it helpful. So, my lord, my ladies, I was going to, if I may, take the grounds out of order, just because the second ground relates to the broader point about duty of care and the Act's omissions opposition, and then look at what is effectively an exception or a narrower area in which the duty has been held not to exist, which is the litigation point. I'm happy to do it the other way around if it's more helpful.
Whatever way suits you.
And then I'll come on to Article 3. We've
Do you mean Article 3?
no, to 3. And I've discussed with my learned friend, we would have some hope, but very much subject to you, that we might be able to complete this today, during the course of today.
I must say that had occurred to us.
Yes, so that will be our aim. And that would involve me going on until just after lunch. Mr. Cohen needs less time than me, and then me being fairly
Soon you
concise.
start.
Thank you.
Soon you'll be finished.
Yes. So, ground 2, we argue that stepping back from this claim, what the appellant complains of is that the respondent caused him foreseeable personal injury, and that he did so by a course of conduct which made things worse, and that in those circumstances, without more, a duty of care is established. That's the submission we make, which underlies ground 2, and of course we say that the judge below, with respect to in law and his approach to the inquiry which he was required to make.
Sorry, pick you up so soon. Formally, we are concerned with the judge, with the county court judge. So we're talking about she, not he.
Yes. So
it's true there are 1 or 2 points at which the judge, Justice Choudhury, says that the judge below got it wrong and substitutes different reasoning.
Yeah.
And there we're obviously concerned with his reasoning, but the primary thing is Judge Baucher, isn't it?
So I was
This is
addressing on the basis that I was inviting you to find that the judge below erred in law.
Wait, judge below, which judge?
So sorry, that Mr. Justice Choudhury erred in law in failing to find that Judge Baucher was wrong.
That obviously
yes.
is formally the right way of putting it, but the ultimate question then is was Judge Baucher wrong?
Yeah. Yes,
doesn't matter, but I just think we need to make sure we keep our eye on the right ball.
my lord, yes, I'm. Again, I will try to look through the judgment of Mr. Justice Choudhury to the judgment of
On a lot of the points, it doesn't really matter because it's a point of law, and we've got to decide what the right answer is. But as a matter of analysis, we're looking at the first instance judge.
Yeah. So that's a summary of our underlying submission for ground 2. The underlying submission for ground 1 is that although the claim relates to the respondent's conduct in litigation, that doesn't negate the duty of care. Firstly, because of the context of the litigation, and point which my Lady Justice Andrew made in granting permission about the stage, the sequence of events which included the litigation. Secondly, because of the nature of the litigation, which is statutory appeal in the context of asylum. And thirdly, because of the nature of the harm, which was foreseeable personal injury rather than pure economic loss. And we say that...
Mr. Chirico, if I may say so, in relation to that point, there might have been difficulty if the litigation was still ongoing during the whole period of the delay. But once the time for appealing had been exhausted, and then there was a failure to act thereafter, speaking entirely for myself, I can't see what the litigation has got to do with it. The parties are no longer in an adverse position at all.
My lady is not speaking entirely for herself.
Well, it may shorten some of my submissions on that point.
I think you may find that on this particular aspect, you may still want to say something about it, that Mr. Cohen has more work to do than you do.
Right, that's a helpful, I'm grateful for that indication, yeah. And then on the third point, I'll come to Article 8 when we get there. So, can I, just before then dealing with ground 2, very quickly skip through the facts. They're fairly straightforward, but I'd just like to draw your attention to 3 or 4 points. I can refer to the judgment of the County Court, which has the full exposition of the facts. So that's in the core bundle, starting at page 142.
Oh.
13. And the facts are recited at page 144 onwards, and as
you can take it that we
yes.
have all done our own analysis of the facts. So you just draw attention to the ones that you rely on in particular.
So first, the overall time frame. So page 145, paragraph 13. The background to all of this process is an initial 5-year delay in determining representations, and that's relevant to, in particular, the Article 8 ground.
Is it? It's not pleaded as a relevant delay for the Article 8 ground, is it?
And the judge describes this as part of the events prior to the material period.
Yeah. Well, so maybe I won't say more about that.
Isn't the time frame 10th of February onwards?
So the time frame in which it's said that the breach takes place is the 10th. The only reason why I'll refer to the overall context is in response to the Secretary of State's justification for delay, and I will say that the time frames are relevant to the Secretary of State's ability to justify delay. Maybe I should come to that in the context of Article 8, and it may be that there's not much to that point. So the second feature of the facts is at paragraph 16. And just to emphasise that paragraph 16 is the point at which we say the Secretary of State was on notice that harm that personal injury, that psychiatric harm to the appellant was foreseeable, and that notice is given in the course of a public determination of the error of law question by the upper tribunal, and you have that in the supplementary bundle. I don't need to take you to it. Just to emphasise, it's not a file note or an informal communication. It's part of a written judgment.
It's the reason why they say that the upper tribunal
Yes.
should remake the decision rather
My lady, exactly.
than the FTT.
Yeah, because it can be case managed more effectively by remaining in the upper tribunal. Exactly. Then the third point is the file note. So it's over onto page onto page 149, file note 44. And this gives us the context in which the respondent is waiting for a final sign-off. In other words, it appears that from that comment that and indeed from some of the comments previously, that the Home Office was already aware that this appeal might not be pursued, but that it was awaiting a final sign-off. No further challenge proposed. That's a quite surprising file note in circumstances where there was a pending appeal to the Court of Appeal. And then the next point is the note which we attach weight to, and the Secretary of State says we attach too much weight to, which is paragraph 46, the file note, which is the sign-off file note from Mike Wells. And the important features of that sign-off are that Mr. Wells, firstly, that he is plainly the person who has to make the decision about whether an appeal will be brought against the upper tribunal's decision. Secondly, that he has previously expressed concerns about the Home Office position. So it's something the Secretary of State was aware of. And then that, thirdly, the quote, which is strongly worded, but not just a sort of jury point, that the opinion of the final decision maker on this is that bringing this kind of appeal, not just this appeal, but this kind of appeal, is a waste of taxpayers' money and futile, and it's a futile attempt to court. And again, we say that goes directly to the Secretary of State's ability to justify conduct in this period, because insofar as justification for Article 8 purposes depends on the economic interests of the United Kingdom or on the public interest in deporting offenders, then that's, we say, a strong indicator that this particular attempt to pursue an appeal and delay removal wasn't going to pursue that aim at all. And then finally, just going back to page 146, paragraph 22, and this is, my lord, my ladies, you're from what we've just been discussing, you're clearly aware of this. The 10th of February 2016 is the point at which at which the appellant's appeal ceases to be pending. There ceases to be any pending litigation, and we say that the relationship between the parties reverts to that of an immigrant and an immigration controller, or a refugee and the person who's due to grant
Are you
asylum.
going to look at paragraph 48 and the fact that the wrote on the 19th of May saying they would grant leave? There's then a delay in the appellant providing information till the 16th of June,
Yes.
and then a grant on the 23rd of July.
So the appellant unfortunately was in hospital.
No,
by
I'm
that
not
time.
criticising him.
No.
But that's the chronology.
That's my lady. Sorry, yes, I was trying to be that I was being over economic in the paragraphs I took you to, but absolutely the chronology thereafter is the two-month period of which half the time is waiting for the appellant to provide biometric evidence. Yeah.
Can I just caution against an ambiguity in the word delay? There is a 5-month period between the expiry of time for appeal and the slightly more than 5 months, but there or thereabouts, and the grant of a settled status or grant of leave to remain. That is in one sense delay and is referred to as the delay complained of, but on any view no one was expecting that the very next day there would be a grant of leave to remain. At least a month, or about a month, as we have seen, is taken up by obtaining the biometric status, the biometric details, but there would be perfectly legitimate administrative decisions still to be made. You've got to decide how much leave to remain and so on. Yeah, so on any view, we're not talking about 5 months or even 4 months culpable delay. There is clearly a substantial, you would say, culpable element in the delay, largely caused by the failure to decide whether or not they were going to try and appeal out of time. But we're not really dealing with a 5-month period of culpable delay, are we?
My lord, no, but in response to some of that, of course the 5-month period of again, so using the term delay, the 5-month period from the expiry of the opportunity to appeal to the grant of status follows on from a month when the Secretary of State already should have been, presumably would have intended to be considering whether to appeal or not, and should have been aware, we would say, of the need to act quickly.
But so what do you say is the culpable delay?
So, so we would say that the culpable delay, realistically, and my lord, I absolutely accept what you say about the need for a period of consideration of what leave to grant and so on. We would say that a month would have been a reasonable period from the end of the from the expiry of the appeal period to the grant of status.
A month to say it'll be a 5-year leave to remain, and then a month for your client to produce the biometrics.
My lady, no. The reason a month was taken was because he was in hospital. Otherwise it could have been done immediately. So there would have been no. So that
he didn't
delay.
go into hospital until May, did he?
So he went into hospital, I believe, on the
18th
of May, and he wasn't informed that he would be granted leave to remain for 5 years until the 19th. So
your point is that if the Secretary of State had a month or 4 weeks from mid-February to mid-March to notify your client that he was going to be given status of 5 years or whatever it might be, he would then have produced the biometrics because he wouldn't have been incarcerated in a and that didn't happen for another 2 months anyway. So even if the Secretary of State had left it till April, he could have produced the biometrics earlier.
Well, exactly, and also it is. So the decision to grant 5 years leave to remain, so the decision part happened very quickly from the so the decision to not to pursue the appeal was taken on the 10th of May. It's 46. The letter stating the intention of granting 5 years leave to remain is only 9 days later. There's then the delay in obtaining biometrics, and the appellant had been hospitalised the day before, and then there's the period of five or 6 weeks for granting status. Now we can complain at that in the ground, so that's identified as a further unnecessary delay in the grounds, and I would say realistically that a month for the decision about length of time, and then the supply of biometrics, and then the decision, which could have been faster than five weeks given what was known about the claim. And my lord, my ladies, also again, sorry, I'm ending up skipping around, but you will have seen that from February onwards, really very promptly, my instructing solicitors were writing letters saying, please do act quickly. So the respondent was being reminded.
Yeah, and at some point, he's not even getting replies.
Yeah.
Mr. Cohen will be able to help us about why that was.
So that was all I wanted to say about the facts. Can I go on then to ground two? So the So we say that the first thing that had to be decided in determining whether a duty of care is established in a case like this was whether stepping back, the conduct complained of relates to causing harm or failing to make things better. I was going to take you through the authority. It may be that I don't need to. So the summarising authority is called paragraph 28, which is at page 527 of the bundle. It may be worth just spending a moment in it.
Yeah.
So page 527, that would be
Sorry,
five.
you excuse me. For ease, I put through into my core bundle. I just neglected to put it back. Won't take me a second. Sorry, yes, I'm there.
So this paragraph 28 follows on from a summary of the judgment in Robinson, which I'm not taking you to, but at the moment, but the question in Robinson was whether the police were not liable in negligence in circumstances where a decision had been taken to arrest someone in a busy marketplace, and in the course of that arrest, everyone fell over and fell on top of a woman who was injured as a result. And the argument which was advanced in Robinson was in part pretty much an argument of immunity from suit for the police, certainly for the police when acting in the course of their statutory powers. And that was rejected in Robinson. I'll take you to that in a moment in a different context. But what Lord Reid then draws from Robinson in Poole is the core distinction which underlies all of the authorities that he discusses, which is the distinction between causing harm, making things worse, on the one hand, and failing to confer a benefit, not making things better. And he explains that more explanatory terminology is more helpful than acts and omissions. And this explains why the two kinds of conduct are different, and why they would found different responsibilities or duties. And so the core distinction is between causing harm and failing to confer a benefit, and that private individuals are in precisely the same position as public bodies in relation to those two categories of conduct. There is no difference. So at the start of 28, the fact that a public body is exercising a statutory duty does not create proximity, doesn't create a duty of care. That's the argument that's the suggestion which had been rejected in cases like Stogan and Wise. So there's nothing special about a public body, which means that there will, as a matter of course, be a duty of care towards the public who that public body is intended to protect. In the same way, there's no immunity from suit. There's no reason for public bodies to have less liability or less of a duty of care. And the second point made there is that in a pure omission case, it's necessary to show something more. And my lord, I think that was the context of the case that you referred us to yesterday, which turned on the question of whether it was necessary to always to establish an assumption of responsibility, and the answer was no if the harm wasn't foreseeable in any event.
Yeah.
And no, as a matter of but what's identified here at the bottom of paragraph 28 are some of the reasons why a public body, just like a private body, just like a private individual, might have a duty to protect from danger if the public body has created the source of the danger or has assumed responsibility. The examples given there. And then that's the section of Poole which deals with the distinction between causing harm and failing to confer a benefit or failing to protect from harm. And then further on in the judgment at 538, or page 538, paragraph 64 and 65, the Lord Reed returns to Robinson and this is the section again which my Lord the Vice President referred to in earlier this year, and is also referred to in cases that we'll come to in a moment, that there is no need to apply the Caparo test and to ask all three questions every time.
But any of this is in dispute, is it?
My Lord, no. I don't think it is. So
And
shall I
these
go
passages were sidelined, and speaking for myself, and I'm sure my ladies have read them
Yes,
carefully.
well, so
just walking us through Poole, you must of course show us the passages which are central to your submissions, but
Yes.
I don't think you need to spend a lot of time on it.
My Lord, I'm grateful, so I won't spend any more time other than to draw your attention again to the top of paragraph 65. So public authorities owe a duty of care. There's no distinction between public authorities and private individuals in the allocation of duty for tort unless such a duty would be inconsistent with and therefore excluded by the legislation from which their powers are used to derive. And there's, I think, no suggestion that there's any legislation which would be incompatible with imposing a duty of care in general terms on the Secretary of State or the Home Office when it's conducting the kind of decision-making process which is the subject of this claim. Subparagraph 2 of 65 is an answer again to the question of whether simply being a public authority creates the duty. And then subparagraph 3 again, the set of particular additional factors which are necessary before an omission, a failure to provide a benefit or a failure to protect will give rise to a duty. So that's the first distinction, is between a fundamental distinction, so which cuts right across public and private, public authorities and private individuals, which is the distinction between causing harm and failing to make things better. The second big distinction, which we say runs through all of the tort of negligence, is that between personal injury, including psychiatric harm on the one hand, and pure economic loss. And so that it is referred to quite frequently in the authorities in the Barclays Bank case, page 71 of the bundle, paragraph 31. I'll come back to this on the this authority on the litigation point.
So, but you are coming to it now. You take
No, I'm coming to it.
passage now.
I'm sorry. Yes, I'm coming to it now first.
Yeah, well, okay.
So,
Which page did you
page
say?
71, paragraph 31. So this was the case about the freezing order not being complied with by the bank. And in cases of pure economic loss such as this, so the bank has failed to protect the money, it's not sufficient, reasonable, so foreseeability is not sufficient. But in the case of personal or physical injury, the reasonable foreseeability of harm is usually enough to generate a duty of care in case of economic loss.
That's a very general. But obviously, we all know that in certain circumstances, the nature of the loss can determine whether a duty exists. But it's not a sort of universal rule that.
So
he only says usually he hadn't got this kind of case in mind. I'm not sure this really helps it, does it?
well, it puts down a marker which is a consistent marker that claims relating to.
The court will be more willing to recognise a duty of care to prevent personal injury than to prevent economic loss. I don't think you'll find Mr. Cohen disagreeing with that as a general proposition. But the question of how it applies in cases of the present kind, failure to take action by a public authority as part of its statutory duty, or delay, which is a form of failure to take action, we really got to look at what the authorities say about that.
So, yes, so I'm not suggesting that this trumps the. This is why I've done these. I've taken these in this order. I'm not suggesting that causing that personal injury trumps the omission action. Sorry to go back to that, but it's just shorter. But I'm not suggesting that. So, a failure to protect, which gives rise to personal injury, will not give rise to a duty unless these additional factors are in place, and that's clear from many of the authorities are about people.
Well, some of the key Stoneman and White, all those
Exactly.
road signs cases, all
Yes.
of that.
And about Tyndall, which we'll come to. So I'm not. It's the other way around.
So what are you positively saying?
So I'm positively saying that where there is an act, not an omission, that it will normally be sufficient that the act foreseeably causes harm.
So you're saying that this is an act case. What is
So-
the act?
So the act is the act of taking steps which delay the. So it's taking active steps which delay the granting.
They didn't take any active steps. They simply omitted, relevantly, they omitted to grant leave to remain as quickly as they should. Surely this is an omission case, isn't it?
Well, so I'll have to address you on that. Well, our submission is it's a case which has mixed omissions and actions, and that when you step back from it, it's a case about acts.
Okay, but if you persuade us that this is an act, that's where it becomes relevant that it's personal injury.
Yes.
Okay.
Well, that's what Mollo, that's where it becomes determinative. We would say it's always relevant for the reasons that you gave before. The court is more likely to find that there's a duty where what is being claimed is that there was a foreseeable personal injury, but in a context where you have both causing harm, so an act, and the harm that you cause is foreseeable personal injury, then that should be enough. Certainly, it's usually enough.
Very well. Okay, so we see the general proposition that you get from Barclays Bank, as you say, you could get it from a myriad of places.
Yes,
What
and
else do you need to show us on this?
Can I get it from another place as well? And but where they're also
So you finished with Barclays Bank.
we can turn from Barclays Bank to Robinson. And so Robinson is at tab 27 of the bundle, page 645.
Sorry, which page?
645, my lady.
At 618. Oh, you want to go to 618?
Sorry, I want to go to page 645, paragraph 83, sorry.
Sorry.
Which paragraph?
So it's paragraph 83. This is Lord Mann's.
Yes, I haven't consciously read this. Why don't I just quickly read it to myself?
Yeah.
Just 83?
Yeah.
Yes.
And then the next point is that there is no automatic opposition between causing harm and failing to make things better, and acts may partake of both, and they may be able to be characterised or even pleaded as both. And so the backdrop, sorry to jump around, so I'm in Stovin and Wise now, page 703 of the bundle, tab 29, page 703. And this is the case where the local authority had failed to force or to require fail to make a landowner reduce the height of a bank, with the result that there was reduced visibility on a turning and the claimant was injured in a traffic accident. So the background is clearly an omission. And at 945, so Lord Hoffman gives the judgment which is normally cited, 945 C to E, that's the sideline section.
Yes.
And so,
Well, I'm not sure this doesn't say the opposite of what you said. Of course, he says you can always find acts and omissions in any chain of causation, but he also says the court can make a common sense decision as to what the real nature of the complaint is.
my lord, absolutely, yes. And so
I don't think that was quite what the proposition for which you were advancing.
So the proposition I was advancing was that that an event always consists of acts and omissions.
Yes, but so what if, as Lord Hoffman says, the court will characterise it as one or the other?
Yes, no, I'm. But the fact, so the point I'm making, sorry, it's probably such an obvious point that I didn't need to take it to stone and wise to make it, is that the fact that an act contains some omissions, or that omissions contain an act, doesn't determine or doesn't negate them. That most things are a mixture of causing harm and failing to do things.
Can I just ask you this? Suppose that the Home Office had not embarked upon the unwise decision to seek to appeal out of time. Would you accept that it was all pure omission?
And my lady, yes, can I
I
just
think
check?
you'd have to, wouldn't you?
Yes. Yes.
So in a case where, on all fours with this case, the Home Office had delayed for the same length of time, and that delay had exacerbated the serious mental health condition of an asylum seeker or a refugee or somebody, there would be no cause of action in negligence. But there is a cause of negligence in this case because the omission to act within a reasonable time was exacerbated by a positive step which added or lengthened the delay.
Yes.
Yes.
My lady, yes, exactly. So what we say is that within this, firstly, absolutely, we accept that if there had not been the taking steps to appeal part of this conduct, this would be an omission case.
Right.
First point.
Thank you.
Secondly, we say that that wouldn't necessarily mean that there was no duty, that there was no duty of care, and I'll come back to that. That's a matter of concession on the part of this appellant, and so I'm not seeking I've conceded, as I conceded below, that if this is a pure omission case, then there will be no duty. The reason why that concession is made is that no assumption of responsibility was pleaded. It's a matter of pleading, and I conceded, and I've discussed this again with my learned friends today, that the nature of the concession I made in the High Court, the concession I made was that because there's never been a pleading of assumption of responsibility, I can't awaken that now.
Yes, I didn't need to lose much sleep over not having pleaded it, but I didn't quite see how you could have. But
well, so, but there are, so my lady Justice Simler in a different case with very specific factual context, in the Husson case, which is in the bundle, considered the possibility of assumption of responsibility, and there are a number of cases which follow on from that, which look at the situation, the circumstances in which the Secretary of State could be held to have assumed responsibility. It might be that you would think that claim would be unlikely to succeed on the facts of this case, but the reality is it's simply not been made. So there would be cases like this one where there would certainly, maybe not this one, but where there certainly could be a pleading, and that is an area of law which is certainly developing, but it's not one I can invite you to develop in this case, so I simply haven't pleaded it.
very well.
So that would be one route, nonetheless, to a duty, my lady. And the other point is that, of course, an Article 8 claim could succeed in those cases, and that's
Well, Article 8 is separate.
yes, exactly. And that is the route to a remedy in cases such as this. But yes, so I absolutely accept that what is necessary in order, firstly, to either to include causing harm, to include a piece of conduct which causes harm, an act, or to convert the whole of this period into an act, is the process of deciding to bring an appeal.
Well, really, therefore, I don't want to hurry you on, you must develop in your own way, but we've really come to a very narrow point, haven't we? You concede no cause of action in negligence unless you can characterise the nature of the thing of which you complain as an act rather than as an omission. And you said you were going to come to that later. Maybe it's enough to come to it now.
Well, I think that now is later.
Okay.
I've got to this point. So, just to say, there are two different ways in which this can be put. We say, firstly, that the respondent was under a duty not to embark on the whole course of action, which was a delay, including the bringing of an appeal. In other words, that stepping back from the whole of the conduct in the period between the 10th of February and the 23rd of July, that what the Secretary of State was doing was acting. And the second way that we could put it is that in the course of that, the Secretary of the Home Office did a thing which caused harm. So did an act which caused harm, and that act was bringing an appeal. And it foreseeably, so this is the way we put that case, it foreseeably caused harm because it was foreseeably going to delay the resolution of the appellant's status. And that was foreseeably going to, because of what the upper tribunal had already said, that was foreseeably going to cause a deterioration in his mental health. And then the agreed position of both experts is that the deterioration in the appellant's mental health was the result both of the delay and of the bringing of the appeal. And I just so if you read the first of those medical reports, the appellant says at one point to Professor Katona, my solicitor told me that the Home Office was challenging, something along those lines. I paraphrase, but it's one of the things.
Well, I mean, I think if you want to show us, you better show it to us.
My lord, I don't need to show it to you because it's agreed. It's the agreed position of the experts, and it's the agreed position of the parties in the case summary that both the delay and the bringing of the appeal were significant aggravating factors in the. Shall I take you to the case summary? Or?
I think that would be helpful because it is quite important.
So
I'm not saying for a moment you're wrong, but we just need
well, there it's probably
chat
good to check, isn't it? So the case summary is in the supplementary bundle that we lodged yesterday. And that's, so it's at page.
Yes, it's the final paragraph.
Yes.
In fact, I see already underlined.
The parties agree that the appeal and delay in granting refugee status, appeal and delay in granting refugee status was a significant aggravating factor. And then the in the joint statement of the experts.
Well, hang on. Can we just look at exactly what is judge? They agree that it was a significant aggravating factor in his and rendered his 2017 to 7. I don't quite. What's that?
It should be 2016 to 17. Sorry, we corrected that in below, and we've gone back to my learned friend's nodding. So it's the relapse that happens between 2016 and
18 May 16.
Which basically leads to his hospitalisation.
Yes.
We don't know, maybe it appears that we don't know actually what the sequence of events was. Clearly the decisive moment, or the dramatic, quite right, but the definitive moment is when he is admitted to hospital, when he will presumably have been exhibiting paranoid symptoms for some days or perhaps even longer before that.
Yes.
Is there an account of that in the
perhaps I should take you to the medical reports in that case. So the first of the Katona reports.
Can I just know which is the one that was annexed to the pleading?
So it's the one that starts at 160. So the one that starts at 173. I'm sorry, we should have included that probably in response to your request, but that's the additional report that was produced once this matter was proceeding towards trial.
Fine. Yes. So which page or which para, whichever, both? It tells us exactly how he got it. I see. There's a long history.
It's quite a long history.
Yes, I see. Well, we can probably find. So the admissions on the 18th. Yes, I see. That's at the bottom of page 165, 318.
Yes.
Yes, I see. He's arrested because he's.
What?
Well, he's already
Is it?
become agitated and
Is it
aggressive on
Should
the
Jammer be
bar.
thorough?
Sorry, lady, that's covered by the reporting restriction. I'm conscious that we're streaming.
Sorry. I'm so sorry.
Thank you.
But is that
That's-
referring
it's
to
the
the
same person,
appellant?
it's the same
It's FXJ is the name
Yes.
that the name
Right,
was given.
I'm so sorry.
So the model, what I was referring you to before is on page 163, paragraph 211. That's his evidence to, or his statement to the consultant psychiatrist.
So I suppose I should formally say I think the chance of anyone watching this and any harm coming of it is remote in the extreme. But to anyone who has just heard the names mentioned, those names are not to be mentioned or used in any way. Thank you.
I'm grateful.
163 is all to do with what was going on in 2015, isn't it? No, what's 165? What we don't really have is very much related to what was happening to FXJ at the beginning of the material period.
So
He seems to be getting worse in February
yes,
at 3:15. And then in March, he becomes agitated and aggressive, and his dose of a particular drug is increased. And then he's not seen again for I'm sure that date must be wrong. The 20th of May can't be right, because it then says in the next paragraph that he was subsequently arrested on the 17th of May. So that's either the 20th of April or the 20th of March.
Or
He was seen in hospital.
Well, then it's out of sync.
Yeah.
Because the
it
word
must,
he
it,
was
logically, it would appear to be a date shortly before
he was
the
arrested.
17th of May, because it's clearly as a result of the doctor being worried and contacting the police that there may have been some delay, but this is likely to be a few days before, isn't it?
Probably the 20th of April.
It could be
yes,
as late
well,
as the 20th.
I'm sorry, I think none of us have noticed this, but I think it must be the 20th of April or something along those. I can ask to see the medical records.
Well,
if it's
frankly, I don't think it's going to make any difference to the outcome of the appeal. It's but it's helpful. It gives us a picture.
Yeah. No, I will ask to clarify.
Well, if that can be identified, that would be helpful.
Yes, well, I'm grateful. My solicitors will have the material which was produced to the psychiatrist, so it should be possible to answer that.
Well, that would be useful. Thank you.
So, yes, but paragraph 211 is so the whole of section 2 of this is quite backwards and forwards temporally. It's the appellant giving his own account of things that have happened since 2015, and I understood that that the appellant's getting his time order wrong in 212 because he wasn't given bad news after he'd been given status. What he remembers is having been given bad news that the Home Office have continued fighting. So clearly he understood that his appeal was over and he'd won, and then out of time the Secretary of State brings an appeal.
Okay. Well, again, I don't think that it's useful background for us, but we see exactly what the agreed position was in front of the court, which is crucial, apart from the fact that the dates have got wrong. Why probably my ladies have picked this up. Why does it say 2016, 2017? He wasn't detained that long. What's the end point of this?
Well, he continues to be quite unwell through the whole of 2016.
Just remind me if you know when was he released? When was he released from detention?
It was
Released from hospital,
yes. It was at the end of June. Yes, 30th of June 2016. You see that from page page 167, paragraph 333.
Thank you.
So the period was about 6 weeks.
Yeah. Thank you. Well,
The-
it's me who's taking you down this road. For my purposes, something my ladies may say that's enough. We need. We jumped off from you showing us what the agreed position was about it being an agreed aggravating factor. There isn't actually a agreed position about foreseeability, but you would say for foreseeability you rest on what Judge Finch said.
Yeah.
Yeah, very well.
Can I just ask you this, so I get it clear in my own mind?
Yeah.
Looking at the second way in which you're putting it, in the course of the period we're talking of, the Home Office did an act which caused harm. Where do you say, at what point in time is there the act, the positive act that causes harm? Is it the decision that is taken to seek permission to appeal out of time? Or is it the act of putting in the notice of appeal? Where is the act? Where does that come in the timeline?
So, my lady, it's the totality of the actions which are necessary in order to bring appeals. The decision to bring an appeal. I'll take you to the timeline just in a moment. Can I just, because you're can I just answer that in 30 seconds? Just because we're in this bundle, and the agreed position also reflects the agreed statement of the psychiatrists.
Yeah, which we have in the
which you have in the supplementary bundle, and
well, again, just show us the exact passage.
so it's page 227 over to 228. We agree that the Home Office appeal and the resultant delay in his being granted refugee status were significant aggravating factors.
Well,
my lord, if liability were found, there would have to be discussions about quantum and causation and so on. We've just
hang on 1 second. We agree. Yes, so the Home Office appeal is not relevant to liability because no one is suggesting they weren't entitled to appeal. Oh, I see. So sorry. No, I'm at cross purposes. No, I'm not reading it properly. Yeah. The Home Office appeal, of course, healed. Yes, and the result. Yeah. Yeah. Thank you.
You couldn't have made any complaint, could you, if they decided to get their act together and applied to this court for permission to appeal in time? So if the Home Office, in the knowledge of the background and what the upper tribunal had said, instead of prevaricating, had got on with it and had appealed within the time limit allowed for appealing, even leaving aside the problems that you would then be an adverse party in litigation, it can't be said that they owed a duty of care not to take the litigation further when they were entitled to do it, surely.
So, my lady, it would. We would then be within the litigation point, but my submission would still be that the Secretary of State had duty in asylum proceedings not to bring an appeal which was futile and a waste of taxpayers' money and so on, but which, when sent to the person who had to sign it off, was treated as being futile. And the duty of right. Sorry
to interrupt you, but at the time we're talking about, which is before the deadline expires under the civil procedure rules, the people responsible for deciding whether to seek leave to appeal or not wouldn't have known of that decision maker's view because that was only articulated after the event.
No, so Malay, that's absolutely right. But what we have said is that there was a duty to find out whether there was merit to this appeal from the person who signed it off before bringing the appeal. So a person had to. There was a responsible officer who was required, and you see from the correspondence, who was required to give their opinion about this appeal. And when finally,
I thought it was with
That's
GLD at that point, isn't it? For
well, it's with this, it's with the Secretary of State, presumably. Again, we don't seek
well,
to.
we can't
No.
inquire that. This is all covered by litigation privilege. We'd have to look. We'd have to investigate the merits and what they were being advised, and I mean that this is covered by litigation privilege. Possibly investigate that question, could you?
My lady, no, but you're not required to, in my respectful submission. What we're not talking about the advice that the legal advice that
Well,
the.
you are. You're saying it was a futile appeal. That
But that's the-
incorporates-
Mr. Wells is a non. Your point is that Mr. Wells is a non-lawyer.
Yeah, he's the Home Office.
But he only comes in much later.
Yes.
That's the point.
But there's no.
But I think, as I understand your case, you say let it be assumed that you can show, maybe because an internal document is leaked or whatever, you can show that they started and that they knew from the start that the appeal was futile but went ahead with it anyway. You would say that was a breach. That was a breach of a duty of care owed to someone who might be psychiatrically damaged by that decision.
Yes. But
That's and is it essential that you can show that they were that was in fact their internal view, or is it enough that you can argue that it should have been their internal view?
So what I think, so the way we have put it is that there should have been a system of internal communication, which meant that the person who was responsible for the Home Office's view was consulted before an appeal was brought, rather than an appeal being lodged.
But
It's
but
not-
in reality, sorry, forgive me, whether or not Mr. Wells himself was expressing expressing opinion as a lawyer by way of legal advice, my lady's point is surely right. In the real world, it's just an accident in this case that you happen to have this particular piece of paper. Normally, it is something on which GLD would be expected to advise and would advise. I can't believe that. Well, I wouldn't go this far. I'd be a bit surprised if the way it works is the Home Office lay people simply write to GLD and say, please appeal. Please lodge an appeal, and oh dear, it's out of time. Well, in that case, please make an application. One would expect they say we would like advice about whether we have a reasonable chance of appealing. That's what would happen in any well-organised relationship between a government department and the GLD, wouldn't it? And GLD would say, yes, we think there's an arguable case here, so we take it we're instructed to appeal, or this is hopeless, don't do it.
Or we haven't got instructions, so let's just issue protectively. All of those are possible. I'm not suggesting that we can look into those. Those matters are obviously protected by litigation privilege. What we have to do, in my opinion, is that we have to take the outward-facing information from the Home Office, including the acts of the Home Office in litigation as being the Home Office's actions and the Home Office's views. We look straight through the lawyers and we assume that the lawyers are the Home Office, and that's what the prohibition on. Well, that's what the litigation privilege does. We don't look into the conduct between the lawyer and the.
But are you really saying then, in a sense, although I can see why it helps you in a jury way anyway, having what Mr. Wells said,
Yeah.
the logic of your position is you ought to be able to argue to us, this is a futile appeal. This was a futile appeal, which they, knowing the damage it was likely to do or liable to do to FXJ,
Yes.
they were in breach of a duty to him in pursuing it. It's pretty.
My lord, sorry. So I think I haven't made things clearer. Our submission is this was a futile appeal.
Yeah.
The evidence of that. So Mr. Wells's statement is evidence of that, and no one has rebutted that. The Secretary of State hasn't put in evidence to say, oh well, there were multiple views on this, or that.
No,
Didn't we need to? That goes behind the litigation. Sorry, the litigation privilege.
think leaving aside litigation privilege, the point you're making is that the Mr. Wells memo or note indicates that there was a perspective within the Home Office that people in the position of this appellant would never get, were always going to have an Article 3 argument that would win because of the knowledge of the conditions back home that they would be subjected to if they were sent there. That's what the evidence seems to suggest. And so you say that armed with that knowledge, there would be a predictability about the fate of any application for permission to appeal. That I think is probably, maybe I'm rephrasing it, but that's as I understand it, the germ of the submission.
My lady, is the germ of the submission, except I would take it further and say that is the only evidence about the merits, about the potential merit of this appeal as well, because
But things develop. I mean, the position in Somalia may change. There may be knowledge within GLD from other cases that Mr. Wells wasn't involved in. I mean, I'm troubled by it being viewed in such a black and white way. I mean, there are nuances and there are arguments that we may not be able to begin to explore because this is covered by litigation privilege, and there are policy decisions that departments might need, policy questions that departments might need to consider and ramifications, and I'm just troubled by that.
My lady, I understand that, but just reading from the facts of this case, there is a person who is being waited for to sign off, and that person, when he he's being waited for, there's already a note saying we don't think we'll take any further action on this.
Yeah.
No doubt that reflects legal advice. I'm not inviting you to speculate about what that is. What we do see, though, is the view of the Home Office, who is the client, who is saying, my view is that these are futile appeals.
And within days of that,
and immediately
they stop it.
Yes, immediately he's obviously signing off. There's no evidence of any further consideration.
This is probably a red herring, but I think we should just raise it. There isn't there, after much toing and froing between the Supreme Court and the Judicial Committee of the Privy Council, recognised to be a tort of malicious prosecution of civil proceedings.
Yes.
And malicious has its tortious meaning rather than... it would be slightly odd, you might say, this sometimes happens, if there was an overlap between that tort and a duty of care in negligence not to bring ill-founded proceedings. Known to be ill-founded proceedings.
It's probably a question to answer in the context of the litigation point, isn't it? But there is a tort of malicious prosecution applicable in civil proceedings. That's right, and we looked that up.
I'm not sure that tort extends to just part of the proceedings as opposed to the foundation for them, or the initiation of them. So if you had a bona fide initiation of proceedings, or the proceedings were initiated by your opponent, it could be said that it was the tort of malicious prosecution to pursue an appeal.
I'm not sure about that, but I think it was characterised effectively as abusive use of civil proceedings, which include both the initiation and any step taken in the proceedings, I would have thought. But we certainly do not on this appeal have to say anything about it, no. But I'm just exploring what sort of duty of care this is and what its implications are.
Yes, I accept that the fact that there is there is potential overlap or at least there is a boundary which could move between the two, is similar, I'd submit, to the relationship between misfeasance and negligence, where recklessness, so the same acts could be characterised as negligent or misfeasance.
Yes.
And so, depending on proof of subjective, and in this case, for example, specifically,
Well,
negligence was misfeasance was pleaded in the alternative up to the High Court.
But you haven't appealed the
We haven't appealed, no.
objection.
But let's just get back on track. What you are effectively saying, and I think we understand it, is that in principle there is a duty of care not to bring a futile appeal in circumstances where it is foreseeable that that will cause psychiatric damage. From that point of view, Mr. Wells's advice is not of the essence, but it is evidential.
Yes.
And in fact, you would say on the fact of this case conclusively evidential, because there was no other evidence about how the Home Office saw the appeal. But that's how you put it.
Yes. And can I just, while then, sorry to go back into the evidence again, but it's necessary to read both judgments together really for this. But if I can take you first to Mr. Justice, so this is the comment of the presenting officer, the recorded comment of the presenting officer on the day of the hearing. We've got copies of that. I wasn't going to hand this up, just in case you need to see it. So
Was this referred to in one of the judgments?
So
Reading from a judgment?
it's referred to in both judgments.
Yes. So can you just tell us where you're reading from?
Shall I just hand it up to you?
No,
Oh,
well,
no, I don't know.
we were saying we don't really need to see it if it's in the judgment.
Sorry, yeah. So the page 66, paragraph 8 of Mr. Justice Choudhury's judgment.
Did you say page 66, paragraph?
8. So it's the rehearing in the upper tribunal.
Yes, that's right, yeah.
So the respondent had acknowledged that the appeal would be allowed in part on the basis of evidence which the respondent had herself provided.
That wasn't that because the judge had made it clear that at the hearing, Judge Ashton had made clear what the position was.
My lord, yes, no doubt, but the Secretary of State had provided the evidence upon which she reached her conclusion. And again, you see, there's just an extract from the comment at 145. So page 145. Page 145, paragraph 17, the County Court's judgment. The reason I took you to the other one first is that that Judge Baucher doesn't record the fact that that Mr. Walker, who was the senior presenting officer, had recorded that the appeal would be allowed.
But where's this going, Mr. Cherrycoe?
It's only going to the fact that the Secretary of State was aware throughout of what the difficulties were with the case. And it's not going any further than that. It's not complete.
But yes, we're just I thought we were on this part of the argument was trying to formulate exactly when the duty of care arose. It's all the question my lady tried to pin you down on earlier. What was the act? Was it the decision to appeal? Was it the totality?
My lady, I'm really sorry I didn't answer your question. I think I got sidelined by other things, and you asked I've totally forgotten. Then asked a question about chronology. So that is back in the County Court's judgment where all of this is set out. So I skipped through this, but on pages 145, 146. And you see just the sequence of events. Page 146, paragraph 26. The CCD, which is the Criminal Casework Department, is writing to seek confirmation that the Home Office hasn't appealed, and then awaiting confirmation from the appeal team on 27, 28. Request for an update from the SAT, that's the Special Appeals Team. So it's not GLD, it's the appeal, it's the client appeals team. And then the PAP is received. This is in paragraph 30.
There are 30. I thought you should be on 26.
Oh, sorry, my lord, I thought
Oh,
I
so
saw you all
26, I see,
reading. I
PAP
thought I saw you all
received.
reading on.
Oh, sorry.
So I was doing the same.
It's entirely my fault, Mr. Chair. I just don't know what are you trying to establish? We're just dotting around among. What's the proposition you're trying to
So
establish?
the proposition is that there was a process by which a decision was taken to bring the appeal, and that's when that conduct started.
Well,
And it's-
when? What date does the process start? What
Well,
is the first act of this process?
So the first act is that there is correspondence and there are requests being made internally within the Home Office to know whether an appeal's been brought. I can't answer that question very easily because it's so
Well,
difficult
it's
to see.
your case. What is on what date does the act rather than omission to act start?
So the Act starts from the beginning of March when the Secretary of State is considering whether to appeal or not. Then on 6th of April 2016, paragraph 37 on page 148, the Secretary of State becomes aware that she has appealed. Well, I'm sorry to put it that way.
I must admit,
I'm
Mr.
afraid, well, that is the way it's put, I'm afraid.
I'm actually struggling with this because I've gone back to the pleadings, which is always a good place to start. And as I read the pleadings, running from about page 186, 187, we've got a chronology of all the various things that are happening.
Yeah.
And it's a chronology of a failure to do things. Treading water, waiting for somebody to say something, awaiting confirmation from SAT, awaiting for this, awaiting for that, Farnex and so forth. Nowhere have I found pleaded in your pleadings a positive case that by the act of appealing or seeking to appeal out of time, there was a duty of care was generated. It may be my fault, but I've been searching high and low for it and I can't find it.
And
Well, 191 and 191 gives the particulars of the breach, and that is all about failing to have a
Yes.
case.
Yes.
and
failing
then
to
likewise 193,
Yeah.
52 failed so to act. Breached its duty, the following failed to take reasonable steps, failing to ensure.
Yeah, so just going through, can I take back to within the pleadings? So the date on which the appellant's representatives become aware that an appeal has happened is on the 6th of April 2016. That's pleaded page 186, paragraph 31.
Well, they haven't filed the appellant's notice at that stage.
No, my lady. So just so I'll come on to them. But what we say is the action of bringing an appeal, and that includes the process of deciding to bring one. And I can't tell you more than.
But where is that pleaded, Mr. Fisher?
So it's pleaded in the.
We've got particulars of negligence
Yes.
starting at paragraph 51.
Yeah.
Well, where is that pleaded?
So it's pleaded in paragraph 51.
50.
And that's E and F. So paragraphs E and F. So it's over the pages on to 192, 193. And so what is happening
Well, that's a
there?
failure to ensure that a fully informed decision was taken, and a failure to act with reasonable competence and expedition. There's no express allegation that pursuing an appeal, which was futile and regarded as such, is the act complained of.
So My lady, I accept that this is not pleaded by reference to acts and omissions. It's pleaded pretty cool, but my submission is that it's very clear what is being said. It's the same as the car and the brake.
Sorry, so you accept that there is no pleaded
no
case
express-
based on an act or a course
No,
of
my lady, I
conduct?
don't accept that.
You don't?
No, I
So
accept
what
that
do you
there is no
accept?
reference to acts and omissions in the pleadings. What I say is that what is being said in the pleaded case at E and F is that an appeal was brought and there was a failure to act with reasonable care and diligence in bringing that appeal. And what's identified in the pleadings is the series of failures to do things. It's the series of failures to act with reasonable care and diligence in the course of bringing an appeal. I accept that you have to
Those are
step back.
particulars of breach, Mr. Chirico. You've got to have a duty of care before you can have a breach of it, logically. So all of the particulars we've been looking at, the failures to act, the failure to do this, the failure to do that, are under the heading in breach of the duty, etc. And these are particulars of breach of the duty. What I was searching for was the behaviour, to put it neutrally as possible, that is complained of as giving rise to the duty, and looking at the whole chronology of complaints of what happened, the overwhelming flavour I get is it's a complaint about delay in determining his refugee status, rather than a complaint about the fact that an appeal was launched which was hopeless.
So, Milady, I'm stuck with the pleadings as they are from 5 years ago, of course. But
they're reflected, aren't they, in the judge's judgment? Because quite a lot of her judgment reflects the chronology as set out in the pleadings.
But Molly, so the chronology. So again, our primary position is that the whole of this period can be characterised as the Secretary of State extending the time, actively delaying the grant of refugee status by deciding about and then bringing an appeal. That is the single factor.
Okay, hang on 1 second. Characterise as the Secretary of State extending the period by actively delaying. And now how did you go after that?
So by actively delaying the bringing of an appeal.
No, the grant of refugee status.
By actively delaying the grant of refugee status by, among other things, bringing an appeal.
Very well.
And we complain in this about, in those particulars, about a series of different failures to act with reasonable care. So they are characterised as failures. My submission would be that it's clear enough from the pleadings, which, as I say, are what I pleaded 5 years ago, but it's clear enough from them that, for example, at paragraph 50, what the duty that's identified is a duty to make a prompt decision on the implementation of this successful appeal on the grant of leave to remain in the UK. And what we say is that by the beginning of February 2016, the Secretary of State, out of litigation, has to decide what to do and makes a decision about implementing. And the decision that she takes is not to implement the appeal, but to pursue, not to implement the upper tribunal's decision, but to pursue an appeal. And that's a decision to take an active step. And then through the breakdown of the breaches,
It could equally be characterised, and the way it's actually characterised in where you just put it is it's a duty to make a prompt decision on implementation, and the breach complained of is a failure to make that prompt decision.
Yes, but within yes, but within that pleading there is there are specific pleadings about the failure to obtain proper advice before bringing an appeal,
Yes. Well, look, I see exactly how you put it.
And that in subparagraph F, had the defendant acted with reasonable confidence and expedition in the matter referred to above, would have decided not to pursue the appeal to the Court of Appeal. See the final assessment of the merits by the footnoted by the officer might well. So the point is that we say that the negligence consists in not finding out what the institutionally not finding out what the institutional thinks about the merits of the appeal, and that causes the appeal to be brought, and that causes the delay. My lord, my ladies, I accept this could have been pleaded more clearly. My submission is that
I don't think you should beat yourself up about this.
No.
I suspect you pleaded it this way because it was the only way it could realistically be pleaded. But that does create a difficulty for you. Well, look.
Well, my lord, it could be pleaded as there was a duty not to bring an appeal which would cause foreseeable harm, and that could have been pleaded. And
you might find us saying that's entirely artificial, because the real nature of what you're complaining about is the failure to make a decision to grant leave to remain. The pleading point is, I'm sure none of us, although sometimes one has to, would want to decide a case on a pleading point. The pleading point, speaking for myself, I find helpful, not because I want to take a technical point against you, but because it reflects, credit to you, the only realistic way in which a case of this kind can be put. Unfortunately, the only realistic way in which a case of this kind can be put comes up against the act omission rule.
Well, my lady says you have my submission on this point, and
yes,
I'd invite you
sorry,
to read the pleadings.
This is what obviously Court of Appeal advocacy is about. You get,
yes.
We take you off your course and explore it. If at the end of exploring it you want to regroup and make sure you made all the points you want to make, please do. But at the moment, I think I do understand where you are and the arguments you advance in support of it. Well,
my lord, my ladies, I'm grateful. I think I will potentially have time to regroup over lunch if necessary. But I'm not unaware that there is a pleadings point that has been raised. It's been raised by the Secretary of State, and I wasn't unaware.
Well, I think you've shown us how you.
So that's the way. Yes, exactly. Well, my lord, I'm grateful. So I think that's as much as I can say about that.
Well, it's certainly not the first time that I've seen a pleading that the Secretary of State owes a duty to make a prompt decision in various contexts. But normally in the context of a human rights claim rather than a negligence claim. This is a somewhat unusual case because of the particular mental health issues which were flagged up in the way that you've shown us.
Yes, and of course I will come back to this in the context of the Article 8 claim where none of these are an issue.
Yeah.
But subject to that, and again, I'm not trying to rush you, I'm just saying that I think we established a little while ago that the essential point on this ground is this an act or omission?
Yes.
We've looked at how it was pleaded, but I think we also looked at the substance. So we have your submissions on is it an act or omission? Is that right?
You absolutely have my submissions on ground too. The only thing I'd like to add is a couple of short comments on the cases of W and Mohammed.
Okay.
If I may, just the other comment, my lady, the answer in a pleading about the duty to take a prompt decision in the context of negligence claim would be to address the question of assumption of responsibility.
Yeah.
And that's that's what's not in the pleading. That's what would fill this gap.
Yeah. For the reasons you've explained
yes.
very fairly.
So yes, can I just quickly then take you to one of the questions that we have raised is whether Mohammed and W should still be following, and if I just very quickly address you on those two cases, and then the case of Adikwa, which is the Scottish case that refers to them as well. So W, first in line, page 753, tab 30. sorry, tab 32, I should say. And it's relied on insofar as it's relied on for what's said at the bottom of 760 and over the page. Sorry, what's said on pages 763 to 764. Can I just ask you, I invite you to read, so starting from paragraph 5 and reading to subparagraph C, 764. And so what is happening there is that the court is is importing the principles which were then understood to apply to the duty of care of police officers or of the police in the exercise of their duties, and importing them across into the immigration context. And we say that that approach doesn't survive Poole, and in particular page 542, so it's Poole, tab 23, page 542, paragraph 74. That's it's relating to different cases, relating to the next case.
Sorry, which page did you say?
So it's page 542, paragraph 74. And on into 75.
Yes, that wasn't considering W as such, but you're saying
No, it's considering the principle of of duty of care owed by local authorities or public authorities in the exercise of their duty.
Yeah.
And then the rejection in paragraph 75 of that consideration of defensive decision making and so on, those policy considerations. And then that's an approach over the page on 543, which is rejected in Gorringe and Michael and Robinson. And that's the re-emphasis on the distinction between causing harm and failing to protect. So the policy-based approach which W relied on is disapproved there, and we say doesn't survive Poole and the authorities that are summarised in Poole.
rather eccentrically, to tell you how confusing it is, one sees at 762, page 3 of proposition 3, Lord Wolfe refers to a case he calls W. That's in fact X.
Yes, I think that's right.
Yeah. So it does sort of plug into.
He does plug into them. It's the ANS period which Lord Reid has been drawing a line under, and Lord Fulson in that set of 3 cases. There are other reasons why W is a very unusual case. So, bottom of page 760, top of 761, it's conceded that plaintiff was lawfully detained at all times, and it's not contended that an invalid decision authorising detention makes detention lawful. This is the case where there'd been a mix-up on the files, and the immigration officers had detained or had continued to believe that the claimant wasn't who he said he was. And then in the middle of 761, Mr. Blake QC was seeking to push forward the boundaries of the tort of negligence to revive a forgotten course of action, negligent detention. That's even in the context of admitting that detention.
Is that? distract us all. Is that concession right? Or has it been?
No, and it's not.
It's been subsequent case law.
So
It doesn't survive.
Lumber. It
doesn't survive Lumber.
So in Lumber, where the Supreme Court holds that a public law error bearing on the decision to detain. So this just wouldn't be pleaded in this way. Though it's obviously pleaded because there was an understanding at that time of the law that's no longer correct, and so there's an attempt to sort of shove negligence into a place where false imprisonment should be reaching.
Yeah.
So, but that's a secondary reason. The main reason why W should not, we submit respectfully, be relied on anymore for a policy-based approach. And then Mohammed follows on from it's Lord Justice Sedley. So that's tab 21 follows on with the same approach. Mohammed is also a pure omission case, which, if you're with me on my submissions, we distinguish ourselves from. But in any event, it's a case about failure to protect and failure to grant. It's a case in which, well, Justice Sedley found the Article 8 claims, but the Article 8 claims should proceed to trial. But before we come back to your main point, do we know what happened to those Article 8 claims?
They didn't generate any reported cases.
No, they haven't generated any reported cases. I assume that they settled. They all arose out of cases. I know they
settled. Who knows?
Your Lordship and my Lady Justice Simler also sat, and perhaps all three of you sat on some of those legacy cases, which those arose out of. There was a large number of them at the time. But no, my Lord, I don't know whether they. I would assume that they must have settled. So this case is relied on for the proposition, for instance, at the bottom of paragraph 24 on page 451, that appears to create a presumption against, or come close to a immunity from suit for public authorities exercising their statutory functions. But in any event, this focus on policy, which is in Mohammed, doesn't survive. It's coming to the case from the wrong end. The first question that should have been asked was: is there an act or an omission? And if there's an omission, is there does one of the exceptions apply, which means that a duty exists? And the third, so again, insofar as Mohammed Mohammed covers a lot of ground, insofar as it's relied on for the proposition that there is a presumptive immunity from suit for public authorities, then it shouldn't be followed. And then the final case in these three is the Adiukwu case, which is at tab 4 of the bundle. It's the Scottish. It's the inner house of the Court of Session. And all we have to say about, sorry, so it's tab 4.
Sorry, all you have to say about it is
that we say that we distinguish it because it's a pure omissions case and it's not an Article 8 case.
But if we're not with you on that,
so if you're not with me on that, the inner house in that case expresses the view that that Mohammed and W are superseded by Poole. It doesn't particularly explain why. We have no difficulty with that. It didn't have any need to explain why, because this is an omissions case in any event. So this is really, so as before, Mr. Justice Choudhury, so now I'm not asking you to disagree with or disapprove anything which is in Adiukwu. Just say that our submission is that we distinguish it because it's a pure omissions case and because it's not an Article 8 case.
Okay.
So that's all I have to say on that, on ground 2. Can I just... Ground 1, I can really refer back to my skeleton argument for this. I'm not sure that I have very much more to add. So skeleton argument, or to our skeleton argument, I should say. So paragraphs 21 onwards. Can I just summarise? We accept, of course, that in the ordinary, as Lord Bingham puts it in Al-Kandari, so Al-Kandari, it's tab 5, page 37 of the bundle, and page 675F of the report. And he says, that in the ordinary course of adversarial litigation, the solicitor does not owe a duty of care to his client's adversary, and the same is true of a party not owing a duty of care to his or her adversary. And we accept that that's the starting principle, and the question is just what is meant by the ordinary course of adversarial litigation. And the second, the case which considers this in most detail, so I'm not going to take you to business computers. We accept what's said said there. It's page 51 of the bundle by Mr. Justice Scott, as he then was, and it's set out in both, I think, in both parties' skeleton arguments. The main case where this is then considered is the Barclays Bank case. So that's the next tab, tab 7. And we referred to the words used by Lord Roger. So this is page 75 of the bundle, paragraph 47. And he uses language which Mr. Justice Choudhury called colourful. So when parties embark on contested court proceedings, they're entitled to, even under the rules of procedure in force, they're entitled to treat the other side as opponents whom they wish to vanquish. And we've explained that it's not, the lack of duty of care isn't based on a kind of warlike approach to litigation. It's just based on the fact that that once you're in litigation, it's assumed that you wish to win. That the aim is to obtain the outcome that you sought through the litigation. You have no shared interest with your opponent in the conclusion of litigation.
That's what adversarial means.
Well, it's one of the things, but yes, it is what yes. So, but it's one of the things we say that adversarial means, because adversarial can also refer to the way in which court proceedings are conducted, notwithstanding that there is, we say, a shared interest in the outcome, and that's what we suggest is relevant in immigration appeals. So can I just take you to the authorities that there's one main authority that we refer to there. So we say that actually before I do that, can I stay in Barclays Bank before to stop you having to jump around, because what we say is that this principle of not owing a duty of care to opponents is restricted, and is expressly restricted to cases of pure economic loss. Doesn't apply in personal injury cases. And we see that in various places in this judgment. Firstly, on the same page, further down, Lord Roger, talking about pure economic loss. But more importantly, back in, and we're going back to this, page 71, Lord Hoffman, paragraph 31. In cases of pure economic loss such as this, and then with reference to...
He's talking about the liability of the bank.
He is talking about the liability of the bank, but he's emphasising that this is a case about pure economic loss.
Well, of course it is, but
well, sorry, I didn't...
It can't be right, can it? Suppose you have a personal injury act. No, that's a bad example.
Suppose somebody has a heart attack when they receive notice that proceedings are going to be
So
issued.
the test is foreseeability,
Yes.
It's known that they've got a dicky heart.
Yes.
and
And
the-
you bring proceedings against them.
but you have to bring them negligently. And
Yes.
So it's not, you're
Yes.
not, so you have to, so you have to both foresee the injury and not exercise reasonable care in doing so. So that would be, my lady, that's what I accept that's the consequence of my argument, that there would be, that if I'm right to say that, that the liability exception is limited to pure economic loss, then the consequence would be that if you brought a claim against a person knowing that you might cause them shock and might cause them to have a heart attack, that I accept that you would, in principle, be liable to have a negligence claim brought against you. That must be the consequence of what I'm saying. And the protections are the foreseeability, and the fact that this perhaps doesn't happen so often, and the requirement of negligence. And so mere ineffectiveness, for instance, in bringing proceedings doesn't amount to a lack of due care and attention. But that's the consequence of what we say is the exception recognised throughout this judgment. I've given other references in the skeleton argument from other judgments within Barclays Bank, so the other judgments, and I think I don't need to take you to all of them. The second narrower reason, and an alternative reason why we say that the exception doesn't apply here, is because of the particular nature of statutory asylum appeals. Because although they are recognised to be adversarial, and we accept that, they're adversarial in the sense that parties go to court and represent and do their best for their clients. There is an underlying and ongoing duty, we say, with the Secretary of State to ensure that if a person is a refugee, that they will be recognised as such.
Is this specific to immigration litigation or any kind of public law litigation?
So we say that it is. We don't argue that it's exclusive because we haven't thought of. We're not sure that we've thought of every other possibility, but we say it is specific to asylum litigation.
Is that right? If you think about tax litigation, there's a duty on HMRC not to pursue points that are bad points in litigation.
So there may be a duty on all of us to not to pursue bad litigation points, or to at least try not to. But my lady, no, is there a shared duty in ensuring that at the litigation stage, in ensuring that the outcome is the only correct one? Because we say that's the effect of the asylum system, there are 2 points. One, there's a shared interest in the outcome, and secondly, that the asylum determination system is a continuation of the original decision-making process. And if I can take you to the authorities on that.
Sorry, can you say those points again?
So firstly, they're interlinked, but they're conceptually separate, which is firstly that there is a shared interest in the correct outcome. So not just in fair procedure or in a heightened duty to the court, but there's a shared interest in the correct outcome. And secondly, that the asylum appeals are a continuation of the original decision-making process to a certain degree. And we say that those two factors distinguish that kind of litigation from the normal run of civil litigation to which this principle attaches.
Can I just well, perhaps you're going to develop them, but can I take the second one first? Continuation of the original decision-making process. I haven't reread the authorities, which I think you refer to, but I'm familiar with them. In one sense, that's that's obviously correct. Most obviously that in an asylum appeal, the decision maker looks at the decisions all over again. The court looks at the decisions all over again. But so are you saying there's a distinction here between a case where the right of appeal to the FDT is only on an error of law against the administrative decision?
So what we're saying generates the shared interest or a duty on the part of the Secretary of State to obtain the correct outcome is that the purpose of the whole of the refugee decision making and then appellate system is to ensure that UK complies with an international obligation towards refugees. So that's what we're saying distinguishes this.
Is that I just want to think that through. You might have said if there's a principle here, it's really about a public authority always wanting or being assumed to want to do what's right. And an appeals system against a decision of a public authority, let's leave judicial review out of it at the moment, but a statutory appeal system is part of the process for ensuring that the state does the right thing. After all, a lot of these tribunals that they've now been, the distance has been put between them since the 2007 Act, were actually internal tribunals of the social security system or the can't think what the others were, but land registry and so on. I'm not sure there is a great gulf fixed between immigration appeals. If your principle is right, I would have thought that it would apply to all cases in which the state was a party where the issue is about the correctness of its own decision making. Now, it doesn't mean you're right or wrong, but it's not necessarily a point against what you're saying, but it does mean that it's much more extensive than you're suggesting by saying it's peculiar to immigration litigation.
My Lord, I think it is a point against what I'm saying because it would be the case, as Mr. Justice Choudhury observed in the judgment below, that, for instance, Barclays Bank itself is a case about customs and excise.
Sorry, your
Barclays
voice dropped.
Bank itself is a case about customs and excise commissioners who presumably would be.
Well, it was my lady's point about
exactly, and
Yes, it is bad. I said bad, but I think my lord is right. It's about the state reaching the right decision in relation to tax or asylum or housing or benefits.
Yes, so that's why we've sought something more specific about the asylum, the statutory asylum appeal system, than just the duty of the state, the heightened duty of the state to ensure that proceedings are fair. And so what we've referred to in the skeleton argument is firstly the case of E&R. This is the case where, so it's in the bundle at tab, sorry, bundle tab 11, and it's pages 209 to 210. And what you see there is a reference to another kind of inquiry, which is both adversarial, but where there is a commitment to a shared outcome. So I accept that that will extend beyond, that principle will extend beyond pure asylum claims, asylum appellate structures. And then at 66, those statutory contexts where the parties share an interest in cooperating to achieve the correct result. And so we say that that is something which is specific to a subset of tribunals, but is not generally a feature of all public law challenges.
Well, it's not evident from this that it's not a feature of all public law challenges. It might or might not be. So asylum cases, planning cases, can't remember what the facts of the Criminal Injuries Compensation Board case were, but presumably it included the Criminal Injuries Compensation Board.
Yeah.
Which he seems to bring in. Well, there it is, yes.
So you have submissions on that. We've
Yeah.
also referred you to the case of MN, which is one of the Sprackhab cases. I don't think I need to take you there. It's another case which talked about the quasi-inquisitorial nature of So, for instance, page 432, paragraph 25. Again, it's not unique to immigration or asylum tribunals, but what we say is it's the nexus of these factors: the shared interest in the outcome, the duty to comply with international obligations, and the quasi-inquisitorial approach of the asylum tribunal. So those are the two principled bases on which we say that the business computers principle doesn't exclude or negate a duty of care in this case. And the third is a factual basis, which is, again, really repeating submissions that I made about ground 2, that stepping back from this, or stepping back from these 5 months, that the overriding relationship between these two parties was that the applicant was a person who had sought leave to remain in the UK and whom the Secretary of State wished to deport. So, in exercise of the powers under Section 1, Section 3, Section 5 of the Immigration Act 1971, the relationship was primarily one of an immigrant and an immigration controller, and that the decisions that were being taken by the Secretary of State in that context should not be seen as primarily litigation decisions, but are decisions about whether to grant status or not. And so, for instance, at the time, around that, the 10th of February, going back into those facts, there was a decision taken whether to grant or whether to litigate. The overriding...
It's a two-edged sword for you, isn't it? You get off the hook of the adversarial relationship, but you're then back into round 2, where you have got to show that there was a duty of care towards someone applying for immigration.
So, my lord, yes. So obviously, the two submissions are in some tension. What we say, the way that we say they're resolved, is that in the course of a primary relationship of immigration controller and immigrant, that the Secretary of State took certain acts, and we say those acts were sufficiently causative of harm that they attract the duty which is identified in pool. And again, the question so the question when looking at whether what the Secretary of State was doing was acting or omitting is, did the Secretary of State make things worse? So did the course of conduct between February and July of 2016 actively make things worse? And we say that certainly on the evidence, on the agreed evidence, it can't be, it's clear that by taking time to think about bringing an appeal and bringing an appeal, the Secretary of State made things worse. And what I had been going to do on ground two, and I was go and look at the case of Tyndall. The only reason I would, so Tyndall was I think I can address it without taking you into the authority itself. But
So are we finished with ground one? I'm so sorry, just to be clear. Have you
I'm
gone back into ground two?
So I have finished with ground one, but I'm addressing. So I've addressed you on the third reason why we say that this wasn't litigation, and I'm then addressing my lord's question about doesn't that put me in difficulties because I'm trying to have my cake and eat it by calling something an action for one purpose and not for that. I'm sorry to paraphrase, but that's the submission I'm
Okay, so Tyndall.
dealing with.
So you don't need to take us through it. Well, happy to go if you need to, but if you don't, you won't. What is it?
So
what's it about?
Tyndall was the case about the frozen ice in the road. A person has an accident on the road, is injured on the side of the road. Police are called. While he's waiting for the police to come, he is trying to wave off traffic and warn the traffic. When the police arrive, with emergency services, he's taken to hospital, and the police briefly put up warning signs to enable them to clear away the debris on the road. But then they take away the warning signs, they leave the ice on the road, and shortly afterwards, someone's killed. So so the question was: did the police cause harm, or did they fail to protect? And the case really turned on a very narrow factual point. Was the man who'd originally been injured, who left, who was taken to hospital when the police came, did the police encourage him to leave, or did they stop him from warning? And Lord Justice Stuart Smith, so on appeal, held that was unrealistic, and that there was no reason to think that the police had made anything worse. The man who was warning would have gone to hospital in any event because he needed to go to hospital. So the question, and he said that what the court asked itself in that case was, stepping back, were things worse because of anything that the police did? And the answer was no. And for that reason, this was an omissions case rather than that case. And that's so the way we have to plead this case, or the way we have to put this case in order to be able to succeed on grounds 1 and 2, is that this is a course of conduct which either amounts, stepping back from it, to an action, or includes an action, but the overall relationship in which this course of conduct takes place is a relationship between immigration controller and immigrant rather than between two litigants. And so that's the alternative answer if you're not with me on either the personal injury exception or the nature of the appeal.
Thank you. So, is that bring us to the Human Rights Act then?
That brings us on to human rights.
Can I just, before we embark on that, just check one point which I meant to raise earlier, to which the answer is probably I don't think we have this. If we look at Judge Baucher's decision, he says that the facts, he basically takes from your skeleton argument, taking out 1 or 2 of the tendentious bits. Not quite effectively what he says. This probably isn't necessary, but it might just be useful over the adjournment, if we could have yourselves and before Judge Boucher. We got it before
Well,
Mr. Justice Choudhury. You
would
brought
like
it with you.
We did. We have both party skeletons. If that would be of help.
Okay, well that was very clever of you.
I was just reluctant to hand anything more up to you until you asked.
It's because I think we need to know quite specifically what the factual basis of all of the case, but particularly this part of the case was. And
Sorry, Mum.
your still an argument apparently is the fons et origo. Forget the Latin.
It's rather a long-
It was taken as being the facts.
Oh, they
Source
go-
much-
oh, sorry, they're already in here.
There is an English word.
It's rather a.
Brought up speaking English, you know.
It's a very watered down font, I'm afraid. But
Yeah, well, I think fons et origo is such a cliche. I can probably get away with it. But, okay, well, you may be about to take us to this, but otherwise, thank you. We'll.
my
I think it's a useful thing to
My
have.
lord, my ladies, I wasn't about to take you to them, as I say. It was just in case you.
No, it was a wise precaution. Right. Okay, off you go.
So Article 8. This is the part of the case where I wonder whether I can go straight to Mr. Justice Choudhury, because this is where he held in our submission correctly that the
Yes.
first instance judge, and maybe I can just adopt what he says
Well,
about this.
yeah, of course you can. In case it just helps you, the way I see it is he certainly disapproved some of the ways in which Judge Boucher put it, and there isn't a respondent's notice. So,
Sorry.
to that extent, we are not interested in what
Yes.
the overstating what Judge Boucher said. However, the way in which he eventually decided it did pick up part of what Judge Boucher said, although it's very short and we won't need. But more generally, I think I get the feel he says this was actually part of what she was trying to get at in the bits I've disapproved. That may not matter, but I don't think it's quite as stark as saying that Judge Boucher's findings are completely irrelevant on Human Rights Act, except for that single sentence on proportionality. But by all means, that was just flagging up that thought. Let's go to Mr. Justice Choudhury.
My lord, I don't really mind where I start.
No. Do what you were going to do.
So my first submission is that the correct approach to the Article 8 claim was to ask the Rasgar questions in order, so the 5 Rasgar questions in order. And the Judge Boucher said that she had regard to those questions, but I think but didn't set them out at all or approach them in any kind of ordered manner. And that was what, in my respectful submission, Mr. Justice Choudhury correctly identified as an error. And therefore, and the consequence of that error, first consequence of that error is that the judge at first instance didn't ask herself whether the Home Office had done anything which had interfered with the appellant's protected right, or it's his right to respect for his, in this case, private life.
Sorry, just say that last sentence.
So because the judge didn't go through the Rasgar questions in order, she didn't ask herself the first important question, which was, has the Secretary of State interfered in the appellant's right to respect for his private life? Will it help just to go to Rasgar so that so the questions are in front of us? So that's in the bundle.
Well, we've got them in, haven't we got them in Mr. Justice Chowdhury's paragraph 86?
Yes.
Yes, fine.
That's good
So,
enough, isn't it?
yes, that's fine.
Yes, that's fine.
So and then having failed to ask that question, the judge failed to ask whether the interference was sufficiently serious as to engage Article 8 and therefore require justification under Article 8.2.
Might be thought that she did ask that question, or at least answer it at 118.
But because the judge had not asked the first question, she hadn't identified the interference, she wasn't able then to go on to. I accept, my lady, that the judge thought that this wasn't sufficient to get on board. This case wasn't sufficient to get on board Article 8.
Isn't what she was saying at the end of 118? This wasn't a sufficiently grave.
Yeah.
But that's because what the judge was doing was counting the months rather than looking at the impact on the appellant. So
Okay.
okay. That's the tone of the finding of the judge at first instance. I respectfully say, and that's an error which Mr. Justice Choudhury doesn't repeat. He correctly identifies that the way the case has been pleaded, it's pleaded shortly, but it identifies the impact on the appellant's right to respect for his private life, in other words, his mental health, as being the interference which requires to be justified.
We just unpack that. You're probably right. It's not pretty clear how it works. Where the interference takes the form of delay, effectively inaction in circumstances where you ought to act, that will have some impact on your private life necessarily in this context, because you will be in uncertainty as to whether you can go on living in the country where you've been living for 20 years. If, because of the particular circumstances of your case, let's say unforeseeably, I appreciate you will say it was foreseeable, I'm just taking the stages, unforeseeably, that uncertainty causes you a psychiatric illness, is that an interference by the state? I'm just wondering what the concept of interference really, how it really works in the context of delay or inaction. Normally interference suggests a positive act by the state. I mean, interfere is actually the verb which appears in Article 8 itself. It's certainly the verb which appears in Rasgar, which is tends to be a word meaning you do something. And of course, Rasgar itself was a case of removal.
Yeah.
I'm not saying, because Mr. Cohen isn't saying, that inaction can't amount to an interference. And Mr. Justice Choudhury thought about this and said he thought it could.
Yeah.
But it's not quite as obvious to me exactly how it works in such a case.
So
you basically say if the inaction has the same consequences as action,
yes,
same difference doesn't really matter.
I'm just trying to think this through. So there are two different ways it could work. One is that that delay is treated as being a positive act in itself, and the other is that delay is treated as being.
I don't think it's helpful. You really only need this part of your case if you've lost on round 2. And for myself, I'd like to focus on delay being inaction,
yes,
or an omission to act. So you're basically saying that whatever the position of common law under the 1998 Act or under the Convention, you have a cause of action for failure to act. That's why this part of the case is important to you. So let's just say it is a failure to act.
surely if the consequences of a failure to afford somebody status to which they're entitled has the impact upon them, leave aside the mental health side of things, that they can't work, can't earn a living, it affects their ability to earn money to be able to live properly.
Yes, so
Then that would be an interference with the enjoyment of their private life.
Yeah.
yes, so I think I may be not answering the right question, not worrying about the right. So in all the cases, my lady, sorry, did I interrupt?
No.
So in all of the cases, for instance, the case which was before my lady, just
Or Mohammed, indeed, which
or Mohammed, exactly. All of these cases are cases of inaction,
yes,
where the delay has had the has had a consequence which is sufficiently severe, because in the Husson case it deprives someone of the right to work for ages, in Mohammed for a long period.
By analogy, the severity of the impact upon your client
yes.
is capable of being an interference.
So I see that, and I wasn't really questioning that.
No.
I was just seeing how you give effect to that analytically, perhaps within the Rasgar structure.
So I thought you were asking who's the subject of the verb interfere. That has to be that interfere implies an act by.
Well,
so
I'm accepting it doesn't, but I'm just seeing how you have to. I think my intervention is not very helpful to you because I haven't formulated it much.
Well,
let's.
My lord, my lady, I'll think about what, if I may, about both of those points over lunch in a few minutes. But so
your proposition has to be, and I think you've got plenty of support for it, not only in the unappealed decision of Mr. Justice Choudhury himself, but also in my lady's earlier case and in Mohammed, that in principle, a failure to grant, or a failure timelessly to grant leave to remain is capable of being an interference. So let's start from there.
So
I suppose what one is looking at it perhaps more is a question of gravity. Does gravity look only at the impact, or does it also require you to consider the culpability or the frame of mind of the state actor?
my lord, no, I don't. Culpability or frame of mind would be irrelevant. It requires you to look at everything and conduct a proportionality balancing exercise. Of course, if there was a culpable decision to deliberately to deprive someone, then Article 8 might fall on the in accordance with the law at the in accordance with the law stage. But
look at the severity, haven't you, or the the severity of the interference with the individual's exercise of his private life rights.
But Lord Bingham uses the word gravity,
Yeah.
so I may as well use that because that's got his imprimatur, or Latin. What I'm just wondering is whether the concept of gravity goes beyond the effect on the claimant, and you're saying no. It's the effect on the claimant. It doesn't matter how culpable a breach it was.
Article 8.1 focuses on the claimant. It's what's happened to this person that requires justifying.
So a 1 month delay, a 1 month culpable delay that has a grave effect is enough to constitute an interference.
Well, it would depend on the facts, and so.
But on your argument,
yes.
You don't look at the length of the delay or how serious the delay is in that sense. You just look at the gravity of the impact.
So what you then have to do is balance at the proportionality
Well, that's at the justification stage. I'm asking you about the interference stage.
But so
to amount to a grave interference, such as engages Article 8.1, you say you just look at the impact on the.
You look at the impact on the individual. There's the question of how serious the act was and how justified it was, how normal it was, is relevant at the proportionality stage. But at the stage of determining whether interference is of sufficient gravity to require justification, you look at what's happened to the person affected by it. and then that so for example, I was going to give the example of length of time as or the length of delay as something which can be relevant in two different ways. So length of delay is relevant in many of the cases, like Mohammed and in Husson, because 1 week of being without work might not be very serious interference, but 2 years will be a very serious interference. Just as a matter of common sense, the longer you're in limbo, the more serious the interference, and therefore the more that will be required to justify it. So delay is relevant in that sense, and then it's relevant on the other side of the balance, because when the Secretary of State comes to justify or seek to justify delay, she can show, for instance, that she's acting, that she has good explanations for the delay. So she can show, for instance, that in those legacy cases that she had 450,000 cases to deal with, and that administratively she couldn't deal with them any faster. That would be relevant to establishing that the delay was proportionate. But if because she would be showing that she's operating, and she can rely on the fact she's operating a system fairly and consistently as part of a justification for the delay.
May have had a severe impact on the individuals concerned, but there was a justification for
There was
it.
justification, then you do the balance, and if the impact was sufficiently severe, and for instance, in those cases that my Lord considered where there were prioritisation policies within the legacy, if the Secretary of State was failing to operate...
Any of those must have been a long time ago.
Well, I'm afraid it was bread and butter for many of us at the time, but so there was during the legacy...
Were there any Article 8 cases?
No. Not that I recall. There were later on, but the ones I'm thinking of were challenges to failure to prioritise within the legacy system. They were public law challenges, policy challenges. But for instance, sorry,
I know the time, but let's just finish off this thought. Take those legacy cases. If you were right, and maybe you are right, but there would have been good Article 8 claims for damages there, because everyone agreed it was a huge failure of administration by you would never have got proportionality off the ground. These were culpable failures.
Well, I'm not sure that everyone did agree that, but I'm not sure that everyone did agree that it was an attempt to. I mean, my Lord, but reading back over the judgment of Mr. Justice Collins in FH and so on, I'm not sure it was agreed that it was culpable. But in any event,
I certainly don't want to refight that battle.
No.
Just testing it against each other.
No, of course, but let's imagine that the context was that a person that a person wrote to the Secretary of State and said, I am suffering from serious mental ill health, or I'm being separated, I can't see my, this was the case in some of those, that I can't travel to see my ageing and unwell parents. Please prioritise a decision in my case. In those circumstances, and then in those circumstances, it would take more to justify the interference than in circumstances where a healthy person had been granted right to work, as many people were under legacy, and was living on in the UK. So my submission is simply that even within the legacy case, it will have been fact-specific, and the system was designed, at least in principle, to filter out some of the people who had urgent cases.
Yes, sorry, I wasn't so much thinking of that's where the confusion, I wasn't so much thinking of the cases of failure to prioritise. I was thinking simply of, and there may not have been...
whether there was no justification at all, but I think that the argument that would have been run by the Secretary of State would have always been that this is our attempt to mop up, to clear up a system where in the end people were mainly overstayers within the legacy. This attempt to deal with fresh claims, and we're dealing with it as fast as we can.
Okay. Well,
that would be the global...
As I said, let's not fight these battles. Well, I see. Well, I think we can. Let's say 2:05. I think this will be quite nubbly, this next bit, but I don't think it'll take very long.
So,
one case law to look at. We're probably still on target.
My Lord, my ladies, I hope so. I hope I won't be more than a quarter of an hour on Article 8 after the break, unless anyone thinks that's too pessimistic. I would have hoped that I would, and then I would hope that we'll be able to get through.
Okay. Well, let's say 2:05. Thank you very much.
All rise, if able.
can you just, have you got notes?
I've got notes, yeah.
Time? I might be a bit more than Robert, how long do you think you're going to be now?
It's still quite short.
Really? Depends.
Well, a lot will depend. Well, I mean, they've already said that I've got more work to do.
I know, but I think that might be before certain things sort of were sorted. It happened during the course of my submission.
Yeah.
I'm not sure that they had. I'm not sure how clear it was that we weren't pursuing an omissions case. So I think that may have taken some of the time away from you. I can't do anything about that. I'm not having that. You know, we really clearly conceded that. So. Yeah, you'd have rightly objected. I'm trying to
How
rewind.
many people will be locked?
Are you
You
okay?
are.
Well, at least I can leave this stuff.
You can leave everything in.
Let's leave everything. I need to read it all again. It's so interesting. It's a really interesting case. I think we possibly.
I was trying to follow along the bounty. I only remember the bounty submission. I didn't see where the change happened because I didn't have like the bundles with me.
Okay.
I was following along. The bounty submission is very fluent.
Oh, really? Let's see where we go with. Let's see where we go with this, yeah.
I'm interested in listening to the ground.
Yeah, no, I must. What I want to do is just. I'm going to sit and write it out. But I'll actually